seeking protection overseas. I've told you several times that there's a long history of international cooperation, so we'll talk a bit about that first. And this is manifested in a whole series of international treaties and agreements which govern IP and IP law. So we just look at some of the most important ones, and the granddaddy of them all is the Paris Convention of 1883. So it's from the Victorian era, and it just shows how long there has been international cooperation in this field, particularly when there hasn't been a lot of international cooperation in other fields. At the moment, most of the industrialized world is, and a lot of the fairly non-industrialized world is signed up to the Paris Convention, 174 countries. China is a relatively recent member, but it joined in 1985, so possibly further back than you might have expected. And the Paris Convention sets out a number of key principles. The first is a right of equal treatment. It provides that, so far as protecting IP is concerned, each state that's party to this must grant the same protection to nationals of the other contracting states as it grants to its own nationals. Nationals of countries that aren't a member of the Paris Union are entitled to the same treatment if they're based in a country that is party to it. So that's really quite an important provision. And it means that you can get the same IP protection in China as a Chinese company or individual, and that a Chinese company can get the same, or individual can get the same protection in Europe and the UK that you can. There are lots of areas where countries discriminate against nationals and companies from other territories, but IP is an area where that should not happen in the countries which are party to the Paris Convention. The next key element that this convention sets up is a right of priority. This is very important. As I said before, when you're trying to get a patent or a registered design, you need to make your application before you make that invention or design available to the public, because it has to be new at the date of filing. And this, of course, presents a challenge if you're wanting to get protection in a number of countries. And this is made a lot easier by a right of priority. And what the convention provides is that when you've made an initial application in one of the countries which is a member of the Union, which would typically be the UK or the EU for a British business, you then have a term in which you can make corresponding applications in other countries, and those applications will be treated as having been filed on the same day as your original application. So when you file overseas, providing you're filing within the specified period, which we'll come on to, the application you make will then have priority over any applications made in that country after the date on which you made your original application. And the upshot of this is that you can file in the UK, then get on with selling your product, promoting it, and you can have some breathing space in which to make a decision whether or not to file overseas, and some time in which to do it. And the treaty goes on to provide for a number of common rules which must be provided by the laws of each country which is a party to the treaty. So, for example, an inventor has the right to be named in a patent and identified as the inventor, and that's something which comes from the Paris Convention, and so all the countries which are party to this must provide for that. And there's a whole series of other generally fairly sensible rules that this convention provides that you have. Next one to talk about is the Patent Corporation Treaty, the PCT, which we saw earlier on top of the international patent application. This has a wide membership as well. 146 countries have signed up to that. China's been signed up since 1994. And this creates the international patent application system. I'll explain a bit more about that later. But it establishes a system which simplifies seeking patent protection overseas. In the end, you always end up with a bundle of separate national patents in each country, because IP rights are national rights. But this sets up a system for getting you there, which helps to delay costs. It doesn't save costs in the end. It might actually be slightly more expensive to take this route. It delays costs and it simplifies the application process. We can do something at the last minute from the UK in English rather than having to file multiple applications in multiple countries. Just to give you an idea of the coverage, the blue countries are signed up to the PCT. So again, most of the industrialised world and certainly an awful lot of potential markets are covered by this system. We've also got a newer treaty from 1977, the European Patent Convention. And this sets up the European patent system, which is a centralised granting system for granting patents in European countries. There isn't such a thing as a pan-European patent. You always end up with a bundle of separate national patents. But if you want to get a patent in the UK or another country which is signed up to the EPC, you can make either a UK patent application, which is considered by the UK Intellectual Property Office and granted by the UK Intellectual Property Office, or you can file an application at the European Patent Office, which is located in Munich, Berlin and The Hague. And the European Patent Office will grant a patent, which is called a European patent, and when it's been granted, it then becomes the equivalent of a UK patent, just the same as if it had been granted by the UK Intellectual Property Office. And it can also become the equivalent of a national patent granted in any of the other 38 countries which are party to that system. So this, again, simplifies the procedure for getting patents through patents in European countries. And this one does save you some money if you're looking at protecting in a number of countries. The unitary European patent, one patent that covers the whole of Europe, has been in the pipeline since 1977, but it hasn't been agreed yet. There are political difficulties. We keep getting close, and we're relatively close at the moment, but there are problems with language and there are problems with courts, because countries don't like giving up their jurisdiction over rights that have an effect over their citizens. So we may or may not get there. If we do get there, it's likely that this system will run in parallel, because there are good economic reasons probably for having a system that lets you get 2 or 3 patents, 4 or 5 patents, rather than protection in 38 countries, which would be more expensive and which you probably don't need. So those are the European Patent Convention contracting countries. So it's not the EU, it's a bit bigger than the EU. And then we've got, this is the third and final treaty we'll look at, the Madrid Protocol. 87 countries are a member of this, and this relates to obtaining trademark protection. China's a member since 1995. And this treaty sets up a system which enables you to obtain an international trademark registration. Again, rights are ultimately national, but the international trademark registration is a sort of beast that sits alongside national trademark registrations, and it covers countries that you choose out of these 87. So it establishes a mechanism for getting protection. So if you want to register a trademark in China, you can either apply to the Chinese Intellectual Property Office for a Chinese trademark registration. That will be granted. You'll have a Chinese national registration. Or you can apply through the international registration system. You obtain a registration at home first. You then apply for the international registration and you designate China as a country that you want to cover. And that system is then processed through WIPO, which is the World Intellectual Property Organization, which is an arm of the UN, which effectively shuffles pieces of paper around the world and takes money off you. It will send the information to China. They will examine the application. If there are any problems, you will have to deal with those objections in the same way as if you'd made a Chinese national application. If you overcome the problems or there aren't any, you then get protection. The international registration covers China. So it gives you the same thing in the end. It's a different route for getting there, and it is more cost effective in most cases. Certainly if you're looking at more than a couple of countries, it's more cost effective than filing on a country by country basis. Mainly because it cuts out the need to have local representatives in each country unless you run into problems, and then you do need one. The UK is also a relatively recent entrant to this scheme. So that's the framework. The laws, as I said, in most countries are much the same, but there are some key exceptions. The USA, almost uniquely, I think, provides for a grace period for filing patent and what they call design patent applications. This means that you can disclose your invention and still get a valid patent, providing you file your patent application within 12 months. The rest of the world, it's too late. So it can be that if you've got something already on the market, you haven't sought protection, it's been on the market for less than 12 months, it may not be too late to get some valid protection in the US. Likewise, as I mentioned before, for the UK and the European Union, there's a 12-month grace period for registered design protection. So again, you have the luxury in the EU of putting a product in the market, seeing how it goes, and then making a decision within 12 months if it's worth seeking some design protection for it. But if you want protection outside the EU and the US, you need to move faster than that. You need to get your first application on file before you put the product on the market. There's also an exception, again, for the UK, EU, almost uniquely. Over here we have a system of unregistered design protection, which gives you some limited protection for design for the shape of articles. You get 3 years in the EU from first marketing, and you normally get 10 years from first marketing in the UK. You don't see similar protection in other countries. So if you're used to relying on that, you can't rely on it elsewhere. And the final exception, which I mentioned before, is that we have access to the community, which is the European Union, trademark and design systems, where you can get a single registration that covers all the countries of the EU, which is much more cost effective than doing it country by country. In the main, everywhere else, you end up with a single national right in each country. And for a UK business, that's typically done in the UK. That's the lowest cost option. And that establishes your priority date. And then under the provisions of the Paris Convention, we've got 12 months before we need to do anything else. And in that 12 months, what we normally arrange is for the UK Intellectual Property Office to do a search on the application, so you get some initial information, some feedback, and a feeling how strong the application is, so you can make an informed decision at this point whether or not to continue in the UK and whether or not to seek protection overseas. And then to seek protection overseas, you file your applications within 12 months, and they claim priority, so they are deemed to have been filed on the same date as the UK application. And in principle, there are basically two routes to go. You either go straight to the countries of interest and file national patent applications, or perhaps a European patent application, or you file an international application, a PCT application. If you go down this route, what that effectively does is hold your options open in those 174 countries for another 18 months, and during that 18-month period, For a UK business, it would be the European Patent Office will do a search on the application, come back with its results. It tends to do a slightly better job than the UK office. So at this point, you're in a slightly stronger position. You've got more information, and you can make a decision whether to continue further into seeking protection. And if you want to do that, you're now looking at 30 months from the starting point. You then effectively file applications in each country of interest. And that's where the big numbers come if you're looking at a lot of countries, because you're moving from one application in English to perhaps an application in China, which has to be translated into Chinese, a US patent application, a European patent application, and then they are all examined by the individual national patent offices at their own speed. Nowadays, if you file a bundle of applications, you tend to find that the Chinese patent office comes back first. So you're dealing with objections from China before you're dealing with objections from elsewhere. And then ultimately, it's up to the national patent offices to decide whether or not to grant a patent, and then you're granted a national patent. The same thing would happen if you went down this route, but it would all happen about 18 months earlier. If you haven't filed here, or if you haven't filed here, if you filed here, but you haven't filed overseas at this stage and you change your mind, if the product is still secret, you could still file a fresh application up to 6 months after this date, because this application will be published about 18 months after filing. So if you file it before that's been published and you haven't disclosed the invention any other way, you're still in a position to get valid protection, but any application filed at this point will be examined at its filing date and not at the original priority date. So the message for patents is that you need to think what you're going to do very early on before you put the product into the public domain, certainly before you go overseas. And so that decision should take care of itself in the normal course of business. You've committed yourself really you're making a decision whether or not to seek patent protection very early on before the product goes into the market. You can hold your options open for up to 30 months in a number of countries, at which point you then have to decide whether or not you're pressing on. Hopefully in 30 months you will have a better feel for whether it's worthwhile committing the expenditure to continuing with patent protection. So that's how it works with patents. Design's much more straightforward. Again, you have a first filing, and for a UK business that would be the UK or the European Union. You then have 6 months in which to file overseas if you want to claim the benefit of the filing date of the original UK application. There is an international design registration system similar to the trademark system, but the UK isn't signed up to it, so you tend not to run into that as a UK business. Incidentally, with designs, because they move faster, certainly in the UK and Europe, you make your design application, it will be registered in a couple of weeks. For something like Bentley Motors, we file design applications for new models before they're launched, and we ask the registry not to publish the design until we say so. You can request deferred publication so that they can have the benefit of unveiling the vehicle at the motor show rather than the patent office doing it for them first. Trademarks. Similar to designs, there is a 6-month grace period. So if you make an initial application, the first application to register a particular trademark, you do that in the UK, you've got 6 months to file overseas if you want to claim priority. And you can either apply directly to countries, or you can go through the Madrid Protocol route, where, as I explained, you might make an initial application, well, you would have to make an initial application, and then you effectively apply to extend that by way of an international registration, choosing the countries of interest. But crucially with trademarks, there's no requirement for it to be new when you file it, so you can file at any time. So unlike designs and patents, where you're forced into making a decision before you put the product on the market, Trademarks, you can change your position at any point, and so then it makes sense to review what you've got periodically. You want to make sure you've protected the trademarks of interest in relation to the goods or services that you're supplying into that mark and in the territories of interest. And that's something which is worthwhile checking every year or so to make sure that you're covered, and particularly when you're about to enter a new market, to see whether you've got protection before you move into that market. Certainly with trademarks, if you're looking at a number of countries or you're going to want to add countries in the future, the international routes tends to be the most cost effective. So overseas, where do we file? The most important place to get protection is your markets. That's the number one place to get protection, because it's in your market that you will lose if there is competition. That's where you're selling the goods. If there's competition in that market, you will be losing. So you need to try and protect yourself first and foremost in your markets. Having covered the markets, if you've still got an appetite for going further, you want to look at your potential markets. Where are you going to be moving to next? Pave the way, make sure, for example, the trademark is available for you to use there, get some protection so that you're ready to move into that market. Having done that, if you've still got an appetite, you might look at where you're manufacturing or where your competitor is manufacturing as a useful place to get protection. And it depends on the type of business you're operating in, because this may well alter. If you are making paint and your key competitor has a paint factory in Belgium, they're unlikely to set up a new factory somewhere else to avoid infringing a patent, unless it's very valuable. So it may be that for you, getting a patent in Belgium is the most important thing you can do, because that's going to keep that one competitor out of the market. In the motor car business, for Europe, for example, we tend to protect in the UK, France and Germany, because that's enough. No one is going to make a car that they can't make or sell in the UK, France or Germany. There's no need to cover all 38 countries, and it certainly saves a lot of money cutting down to just 3 countries. So depending on the business, it's possible to look at how best to protect yourself efficiently without trying to cover everywhere on a scattergun approach. And so I say don't overreach yourself, because in terms of costs, getting protection isn't cheap, but it can be good value. The cost of seeking protection overseas is significantly higher than seeking protection at home. You're immediately into much higher costs. If you multiply that by a number of countries, your expenditure on trying to get protection will go up very sharply. So for example, you're dealing with a UK patent application. When that's examined, there tends to be a to and fro process between us and the patent office. They have some objections. We discuss them with you. We go back and argue the toss. They come back again. And that process may have a couple of iterations. When you're doing that in the UK, you're looking at sort of an example, spending up to say £150 when the objections issue, and depending how complicated they are, a few £100 responding to them. But if you're dealing with a case in China, the objections are issued by the Chinese patent office. They go to the Chinese attorney. They translate them into English. They send them to the UK. We send them to you. You may have spent £500 finding out there's a problem, and you'll be spending a couple of £1,000 going back to respond to that. So it's an order of magnitude almost higher in terms of cost when you're overseas. So think carefully. It's exciting to try and protect yourself in lots of countries, but is it justifiable? Because otherwise you can see all the profits being spent on getting protection that you're not really using. So finally, just some special tips on China. We see an awful lot of problems with British companies' trademarks being registered by Chinese companies and individuals. They're very pleased to see your trademarks, and they're so flattering of you that they apply to register them for you in their own name. And it's done very quickly and easily, and it's very difficult to unpick, because even trademarks which we would recognise as being reasonably well known in the UK simply will not be known across China. And we face this problem time and time again. Well, everyone can see it's a rip-off, they have just taken our trademark, but you cannot convince the Chinese authorities that that mark was well known in China before, as your trademark, before the Chinese applied to register it. So register trademarks in China as early as possible, and certainly before you enter the market. Even arriving with your business card with your trademark on, you're already putting that into someone's hand. It may be too late. Typically, working through a UK attorney, £1,000 should cover registering a trademark in China. It will cost you 10 times that to try and get one back that someone else has registered. And in fact, in most cases where we've dealt with this problem, it's been resolved by doing a deal with the person who's applied to register it in China rather than going through the Chinese courts. For word trademarks, register a Chinese character version if you have a version you're using in China, because that's likely to be more important in the Chinese market, and a registration of a word in Roman letters may not protect you for a Chinese version in Chinese characters. We didn't talk about utility models. They are a sort of mini patent which is quicker and easier to obtain but provides similar protection for a shorter period of time. They're available in Germany, and therefore because China uses a version of the German law, they are available in China, and it's worth bearing in mind because it's a way of getting protection for products relatively quickly and cheaply. The Chinese law, as I say, is quite modern. It's based on the German law, and the Chinese granting authorities, the Patent Office and the Trademarks Registry, are both efficient and fairly quick at granting rights. And they're fairly reasonable to deal with. That side of the equation all works quite well. The problem people run into in China is enforcement, because IP rights are enforced locally in China, and this is where problems arise in the past. A local judge faced with the decision of enforcing the patent and closing the factory or saving 200 jobs may err on the side of saving the jobs. And there's an element of who you know. Matters are improving because Chinese businesses are beginning to export. They want to sell into the West, into the European and UK market. They realise that they're obtaining intellectual property rights over here. We're now working for a number of Chinese companies getting protection in Europe. Chinese companies want protection over here. They want us to respect their protection, and so they're learning that they have to respect our protection in China. So matters are improving. I would say this, but you're better with protection than without it, despite the difficulties. I was in China with Jessica, hello, a couple of years ago, and we were in Chengdu, and we had a talk from the British consul from Chongqing, who was explaining to us at the time that there was a new party leader taking control of this mega city, and he had 5 policies, 5 pillars that he was working on to improve the city. One was dealing with the mafia, the other was improving IP enforcement, and on number 1 they'd already shot 5. So they do mean business, and when the Chinese say they're going to do something, by and large it does get done. So matters are improving gradually. Unfortunately, the guy we're talking about was Bo Xilai, who is now no longer in charge. But IP in all countries is something which we would say it's part of your commercial armory. It's a tool there to use to help the business along. It's not the be-all and end-all. It's not a magic bullet, but it's there to help. It's better to have it than to be without it. And a sensible strategy can help you. If you are wanting to sell in the Chinese market, then certainly getting protection in China is very important. If you are manufacturing in China to sell into other markets, getting protection in your markets first is more important. If there's infringing goods coming out of China into the UK, you can stop that happening with your UK protection. You don't need to enter into the fray in China. But if you're selling into China, then obviously you do need protection locally.